Very good afternoon to all of you, and welcome to part 3 of our discussion of sources of law in Ghana. Again, just to remind you that this discussion is within the context of chapter 3 of volume 1 of our Ghana Legal and System textbook, the second edition. So as we recall from the very first discussion of sources of law, that is the part 1, we made the point that if we look at Article 11 of the Constitution, various sources have been listed. And so we have decided to take them one after the other and probe a little bit more into detail. But what we are discussing here is just a bird's eye view. I think the detailed material, you find it in the book when you have your copy. So, in terms of rules, orders, and regulation made under authority of Parliament or Constitution, which is stated as one of the sources in Article 11 of the Constitution. We are referring to essentially what we call delegated legislation or subsidiary legislation as it is. So laws, rules, regulation, orders, however you call them, are delegated legislation, and they are created by government departments, local authorities, and other public bodies. And the power or the authority to make such delegated legislation, be it laws, rules, regulations, and orders, are derived from the Constitution or an act of Parliament, as the case may be. But of course, when we say from the Constitution, one will say that, all powers are derived from the Constitution. And if that is the case, then even acts of Parliament are also falling within this definition. No, that isn't what we mean. We know that when it comes to primary legislation, the Constitution has vested authority in Parliament, and Parliament passes bill into acts of Parliament. We discussed that in part 2 of sources of law, which we've also uploaded on the Ghana Law TV. Now, we are looking at laws other than the primary legislation, which are made pursuant to powers derived from the Constitution. So we'll be talking about the constitutional instrument, right, as one example of delegated legislation, and other forms of delegated legislation which are made pursuant to an act of Parliament rather than maybe direct provision of the Constitution, as it were. So examples of delegated legislation, as we said, government ministers or ministries may make delegated legislation pursuant to primary legislation. So there'll be a parent legislation, and that parent legislation says that a particular ministry or particular minister may make delegated legislation in the form of maybe legislative instrument, so as to provide rules and regulations to supplement things stated in the parent legislation or the acts of Parliament. And such rules and regulations, which issued as delegated legislation, are meant to address areas which are not detailed in the primary or the parent legislation. Parent legislation usually is supposed to give a general framework of the legislation, as it were, and certain details, certain nuances will have to be worked out through delegated legislation. So the relevant sector ministries or sector ministers may be given the power to do that. Another example of delegated legislation, bylaws, which are issued by local authorities. District assembly, metropolitan assembly, municipal assemblies, and addressing very local matters like parking or maybe noise control, public safety, market tools, and things like that. So those matters are very localized, and that is why the relevant Metropolitan Assembly, Municipal Assembly, or the District Assembly will be issuing the laws which will govern them. Then again, Bank of Ghana also, as a statutory body, is empowered by its parent legislation, the Bank of Ghana Act, and as well as even the Constitution, which set up the Bank of Ghana as an entity to oversee monetary policy of Ghana and ensure microeconomic stability. As far as our currency matters are concerned, may issue directives to regulate financial practices and ensure stability of the financial sector. So these are some of the examples of delegated legislation. If you go into our chapter 3, we have cited a number of case law, and some of these case law actually emphasize the supremacy of the parent legislation over delegated legislation. Of course, delegated legislation are necessary and functional. However, they must align with and not contradict the primary legislation under which it is created. So you know the doctrine of ultra vires. The doctrine of ultra vires, the power to make delegated legislation emanate from the parent legislation. And if that is so, the delegated legislation should not be made in excess of the power envisaged by the primary legislation, or it must not contradict or violate provisions of the parent legislation. And that's Doche will say in the Public University High Court Accra that delegated legislation is subordinate to Acts of Parliament. Now, the question we need to confront is that, is there justification for delegated legislation? Why delegated legislation? If Parliament, according to Article 93, 94, 95, is the law-making arm of government, why shouldn't Parliament be making all the laws in Ghana and we still have delegated legislation? Well, to start with, delegated legislation, generally speaking, is a necessary and practical approach to modern governance. There's no debate about that. And it allows law-making bodies, legislatures, to focus on major legal frameworks while delegating the detailed regulatory authority to specialized agencies. So in terms of a point, we say that, number one, delegated legislation is necessary because it ensures efficiency. It ensures efficiency by preventing legislative overload, especially when it comes to technical responsibilities. There are certain legislation which is so technical that you don't expect the parent legislation to actually spell out the technical details. And you may want the technical details to be spelled out in a subsidiary or delegated legislation. And of course, such arrangement is quite impactful. Why? Because it streamlines legislative process and it also enables faster response to societal needs and reduce time to implement laws. So just imagine if we have, for example, legislation on, let's say okay, now we have the National Building Regulations, okay? And that is an airline which was actually made pursuant to a primary legislation. It used to be like the Local Governance Authority Act. Now, in terms of the building sector, changes are occurring every now and again. In terms of materials which are put on the market and all that. And for that matter, certain things which are useful now in maybe 3 months' time may cease to be useful because there has been advancement in production of certain building materials or certain techniques of building. And you don't expect that you'll be going back to Parliament every now and again to go through the process of legislation, which we discussed yesterday when we look at sources of law part 2. Now with delegated legislation, you can do the necessary adjustment to reflect the necessary changes in the particular area of the law. So that is efficiency we are talking about. And again, expertise provide another justification for delegated legislation because delegated legislation leverages or enables advantage to be taken of specialized knowledge of experts in specific fields. So you want to do something in the area of engineering, you're legislating something related to engineering, or you're legislating in relation to, let's say, public health and so on. You need people who have proper expertise in those areas so that they can think out the rare problems and what need to be adopted. So the parent legislation will just lay out the broad framework, the main philosophy, the main principle which the lawmaker would like to legislate. And then the details of how to ensure that those principles are achieved are actually worked out by the delegated legislation, as it were. And of course, the utility of such an arrangement cannot be overemphasized, as it enhances quality and effectiveness of legislation and also ensures that complex issues are managed by those best equipped to understand them. Let's look at Parliament. We don't have any technical requirements in terms of knowledge background, which you should have before you are elected to Parliament. So you can have over 200 lawmakers who may not have the needed expertise to be able to meaningfully provide for certain areas that need to be legislated upon. And delegated legislation will enable lawmakers to invite those with expertise to work out the details, as it were. Then another justification is that delegated legislation also enables flexibility to be attained. It's flexible because the process of making it, as you will notice, is relatively simpler than a legislation. The legislation has got a whole lot of processes and procedures, except where, as yesterday we noted in the source of law part 2, you want to use certificate of agency, in which case you'll be exempted from certain laborious process. Otherwise, if you are going through the usual routine for lawmaking, it's quite laborious. But delegated legislation is relatively simpler. And you notice that the delegated legislation, all that is required is that when the draft is ready, the final draft is ready, it's gazetted, and then for 21 days, and when it's gazetted, it's also laid before Parliament. Parliament has got a standing committee known as Committee on Subsidiary Legislation, and it's their duty to monitor or oversee various delegated legislation. Now, if after 21 sitting days, Parliament does not annul it, that is, abrogate it, then automatically it will enter into force. And Parliament cannot make amendment to it. It can either approve it or reject it outright. So you notice that it's relatively simpler to get delegated legislation done as it were. Delegated legislation has got various types and can take various forms depending upon the purpose which they are serving, and also depending upon the authority under which they are made. So therefore, we have statutory instruments. And statutory instrument encompasses a broad range of regulations and orders which are legally binding and made by public authorities. So examples are executive instrument. But for executive instrument, for example, we have to say that not all executive instruments will count as delegated legislation. Some executive instruments are purely administrative. They do not have legislative character. Now, the executive instruments which have got legislative character are the ones which will count as part of delegated legislation. So let us keep that in mind. Then, of course, we've also mentioned the bylaws. They're made by the various district, municipal, and district assemblies. And then we also have the legislative instrument, what you call the LI, legislative instrument. And just like the bylaws, they are supposed to be laid before Parliament as well. We also have constitutional instruments. Constitutional instrument, what you call like the CI. And constitutional instruments are made by bodies or entities which are given direct mandate by the Constitution to regulate certain aspects of governance. So a typical example we can cite when it comes to electoral rules or rules which govern the conduct of elections in Ghana. The Constitution has given some powers to the Electoral Commission to issue regulation by way of constitutional instruments in order to govern the conduct of elections in Ghana. And again, when it comes to the law courts in Ghana, of course, in our book, if you go to chapter 2 of our book, we talk about classification or division of law, and part of the discussion there, we talk about substantive law as opposed to adjectival or procedural law. So substantive law is that aspect of the law which tells you what your rights and interests are. And then procedural law, also known as the adjectival law, is that area of the law which is directing you how you can actualize or you can realize your right and interests protected by substantive law. Now, when it comes to the law courts apply the law which actually defines and protects people's interests and rights. However, the law court itself must also follow laws to be able to do its law enforcement. So, in terms of procedures, how cases are presented, how cases are gone into, how evidence is received, and all that, there are laws which govern that, and those laws are part of what we call the procedural law or the adjectival law. Now, if you look at the Constitution, there is a body called the Rules of Court Committee. So the Rules of Court Committee is given the power to issue constitutional instruments to make rules which will govern procedures in the various courts. So, for example, we have the Civil Procedure Rules 2004 CI 47, which governs the High Court and the Circuit Court when it comes to civil cases, and so on. You have the Court of Appeal Rules of 1997, CI 19, which governs the procedure in the Court of Appeal. Then we have the CI 16, which governs procedure in the Supreme Court. So these are all examples of constitutional instruments. Now, One pertinent question which arises is this, that how do you exercise control over delegated legislation so that there are no abuses? And that is very important. And we need to appreciate that delegated legislation, being a useful tool for governance, is subject to specific controls and limitations, which are meant to ensure that they are complementary to the work of Parliament rather than supplanting or taking over the work of Parliament. So that is pretty important. And that is why separation of powers will come in, and separation of powers will let us know that the primary power of making laws rests with Parliament. And that is what the Constitution has said. So lawmaking is a proper province of Parliament. Delegated legislation is only supposed to be supplementary, supporting the work of Parliament, but not replacing the work of and the power of Parliament. And that is why delegated legislation must not encroach on fundamental legislative function or powers of Parliament. As we say, delegatus non delegare potest. When you're exercising delegated authority, you can also not delegate. In the same vein, when you're exercising delegated authority, you cannot go beyond the scope of your authority. So the doctrine of ultravirus, you cannot actually go beyond the scope of that which the parent legislation has asked you to do. Of course, there's also this argument of democratic consent, that how do you ensure that delegated legislation will still pass the litmus test of democratic legitimacy? But mind you, when it comes to primary legislation, we have elaborate procedures which have to be complied with. So therefore, you are sure that it will still uphold democratic legitimacy principle. Okay, with respect to delegated legislation, there's a need for transparency and accountability, particularly so where you are going to allow unelected officials to do lawmaking. For Parliament, they are our elected MPs. So the electorates are giving power or authority to them. But delegated legislation, the various experts and officials who are given the powers to do that, they are unelected. So that is a problem. And so to ameliorate or to cure this difficulty, we need to address the deficit of public scrutiny. If you look at normal lawmaking, there's a public scrutiny. There's an open debate on the floor of Parliament, and the various procedures that we go through, as you saw from our discussion of sources of law part 2 yesterday. And first reading, committee stage, second reading, consideration stage, third reading, and so on. At every phase of the legislative process, you have some kind of transparency and accountability. We can also ensure that various changes can be suggested and effected before you get to the final product. But for delegated legislation, we don't have that. So that public scrutiny is somewhat lacking. Of course, if you look at Article 11, Clause 7, it is a requirement that delegated legislation should be gazetted. But then that is the final stage. Not much input can be made by the public. Well, in the light of all this, it is imperative to appreciate that delegated legislation must also meet constitutional alignment. it must comply with the letter and spirit of the Constitution, just as the parent legislation are supposed to do. And in that regard, the courts play a crucial role in reviewing delegated legislation, and the court will not shirk its responsibility to invalidate any delegated legislation that conflicts with higher laws or the relevant parent legislation. So let us keep that in mind. And it is within that context that we would like to analyze the case of Association of Finance Houses against Bank of Ghana. So if you look at our book, we have discussed that extensively. And what happened in the case of Association of Finance Houses against the Bank of Ghana? The case centered essentially on the nature of directives which the Bank of Ghana had issued. And a question arose as whether the directive which the Bank of Ghana had issued should be categorized as legislative instrument. If it is characterized as a legislative instrument, then it cannot enter into force unless it has gone through the procedure envisaged under Article 11, Clause 7, in which case it will have to be laid before Parliament for 21 sitting days, and then it will have to be published in the Gazette. So that was the issue on hand as far as the case of Association of Finance Houses against Bank of Ghana is concerned. So the question which the Supreme Court was invited to answer was this: does the administrative directive by Bank of Ghana qualify as a legislative instrument under the law, which require the same procedural safeguards as formal legislation? Well, the Supreme Court ruled that the directive issued by Bank of Ghana, despite the fact that it has a far-reaching consequences or impact, do not constitute legislative instruments. And for that matter, they do not have to be laid before Parliament. And this was quite poignant because Bank of Ghana is set up by the Bank of Ghana Act and all that, as well as the Banking and Other Special Deposit Taking Institutions Act. And if the Bank of Ghana is exercising powers under this legislation, is the Bank of Ghana not issuing what we call the LI? So that was the crux of the matter. But the Supreme Court said that no, if you examine it, it didn't have that legislative character. So the Supreme Court premised its ruling on the reason that the directives which the Bank of Ghana had issued were essentially administrative tools meant to ensure the swift and efficient operation of the financial sector. And they could be distinguished from legislative instruments that have a broader legal and societal impact. So that seems to be the reason. As if we take the LI, as in its effect was very, localized, as it were. So the takeaway or the implication of the ruling of the Supreme Court in Association of Finance Houses against Bank of Ghana, among other things, we saw operational efficiency. In what way? By recognizing that what the Bank of Ghana did was just an administrative measure necessary to implement some of its regulatory measures. It obviates the necessity of going through lengthy legislative processes. So that is the advantage. That is why we're saying that that decision ensured operational efficiency for Bank of Ghana, especially having regard to its mandate to supervise the financial sector and ensure stability. And the decision of Supreme Court in Association of Finance Houses and Bank of Ghana also reinforces the distinction between administrative actions and legislative actions. And that is quite pertinent in understanding delegated legislation, because those measures who do not have legislative character will not count as coming under delegated legislation. So let's keep that in mind. So just before we go, let's say a few words about amendment and enforcement of delegated legislation. Well, the point to note that delegated legislation will have to be amended, or it is made. The way it is made is the same way that it's amended. And let's put it simple. So what is the standard procedure then? As we said, delegated legislation, be it CI, be it LI, be it a bylaw, will have to be laid before Parliament. And then when it is laid before Parliament, mandatorily, it must also be published in the Gazette. And then there should be a waiting period of 21 days from the date of the publication. And then when it is laid before Parliament, if Parliament review it and does not annul it, then automatically it is considered or deemed to have been approved and it will come into force. Parliament cannot amend it. So technically, Parliament cannot make any changes to the proposed delegated legislation. All that Parliament can do practically is probably to suggest to the sponsoring department, which is behind the delegated legislation, that why not withdraw it and go and make these changes and bring it again. But on their own, they cannot actually make any changes there. Unlike a bill, when a bill is going through their own process, that one is different. So let us keep that in mind. So look at the case of Mensa against Electoral Commission, where there was an LI by the Electoral Commission regarding electoral boundaries, and there was a controversy as to whether the Electoral Commission had complied with the constitutional requirement for laying delegated legislation before Parliament, and also the publication norms that we've talked about. So look at Mensa versus the Electoral Commission. And you notice that in Mensa versus the Electoral Commission, the Supreme Court examined the issue whether the Electoral Commission had laid the CI or the like before Parliament. And the Supreme Court pointed out that it was necessary for the Electoral Commission to comply with those procedural steps, and they were not just mere formalities, but they had important democratic utility by ensuring transparency, openness, accountability, and also public trust in the legislative process, and of course, the whole of the electoral process as well. But upon examination of the situation in Mensa versus the Electoral Commission, the Supreme Court found that the Electoral Commission had failed to adhere to the mandatory procedures. And for that matter, the LI that the Electoral Commission had proposed, or the CI, was considered invalid. And that case actually underscores the necessity of strict compliance with the procedure to lay delegated legislation before Parliament for 21 sitting days, and also to publish it in the Gazette before, if it is not annulled by Parliament, it will enter into force. So let us keep that in mind. Now, the bigger implication of the decision and the other ones we've seen is that, yes, various bodies or entities are be given the power to make delegated legislation. However, that power is not absolute. It's not ultramarine power. It is a power which might be subjected within stipulated limits. And the limits include the fact that you have to comply with Article 11(7), publish it in the Gazette. It should be laid before Parliament for 21 sitting days. Yeah, I think we've discussed the limitation of separation of delegated legislation already, so we don't need to belabor the point. So I will take any questions that you may have before I leave you. And then when I get time, I'll come online and do other things with you. So if you have any questions, you can put up your hand.